Good afternoon, everyone. Jonathan Cass. I wanted to thank everyone for joining us today for the indemnification provisions, what they mean, and what you should worry about webinar. This is the second in our 2019 series concerning construction contracts, what every contractor and subcontractor should know. I'm Jonathan Cass. I'm a partner in the Cohen, Seglias, Philadelphia office, and I'm a member of the firm's new construction contracts and risk management group. As I said, this is a new group that we put together this year. I'm also chair of the firm's insurance coverage and risk management group. As you can see, I'm the risk management guy in the construction contracts and risk management group, hence why I'm doing this indemnification webinar. So this new group is intended to, what we're trying to do is we want to work with our clients from project conception to completion to simplify the construction process and protect our clients' rights and minimize the risk that they're assuming by engaging in the construction practice, which we all know is a risky endeavor. Should you have any questions during the program, please ask them in the question section of your GoToWebinar panel. I'm going to try to address them to the extent that I have time and that I'm able to do so. To the extent anybody has a question that I don't address during the webinar itself, you're welcome to follow up with me and ask any question that you may have. So what we're going to be reviewing today on this webinar are essentially 5 different topics. Why are indemnification provisions important? How are they interpreted? And we're going to be focusing on Pennsylvania law, but I realize we have clients throughout the Mid-Atlantic region. So I'm also going to be discussing indemnification provisions under New Jersey law, Delaware law, as well as Maryland law. We're going to talk about the waiver of the Workers' Compensation Act, why it's important, why it's critically important to having an enforceable and a robust indemnification provision. We're going to do a review and analysis of some sample indemnity provisions, both in case law, so you can understand how they're interpreted by courts, as well as in some construction contracts. And then we're going to briefly, hopefully if we have time, touch on insurance coverage for indemnity claims, because obviously when you're, for example, a general contractor and you're requiring your subcontractor to indemnify you, although you, of course, are relying on the subcontractor's financial viability to complete the project, it's nice to have insurance coverage to provide coverage for that indemnification obligation as well. So we'll discuss that issue. So indemnification provisions, what are they? Well, in a very simple sense, they're a contractor under which one party, the indemnitor, agrees to assume the tort liability of another, the indemnity, in connection with the claims of third parties arising from services provided pursuant to a contract. And to be candid with you, I always get confused about indemnitor and indemnity. So what I'm going to do for the purposes of this webinar is the scenario we're typically going to be discussing is a general contractor who is pushing the risk associated with the project to the extent they're able through indemnification down to their subcontractor. And under that circumstance, based upon the definition I just read, the indemnitor is going to be the subcontractor and the indemnity is going to be the general contractor. So why are indemnification provisions important? Well, as we all know, construction projects are dangerous. People get hurt and stuff gets broken. And what parties are trying to do through indemnification is they're trying to engage in risk shifting. You're trying to use that indemnification provision to shift the risk associated with certain activities onto another party. And it's typically the party that's performing those activities. And the indemnitor is responsible for paying damages arising from its work. That's kind of the conceptually what you're trying to accomplish with an indemnity provision. So there's three different types of indemnification. And the way I always think about this is there's broad form, there's intermediate form, and there's limited form. So when I'm reviewing an indemnification provision or drafting one, I'm thinking to myself, do I want to make this broad form? Do I want to make it intermediate form? And for the reasons I'm going to discuss later, I'm not making it limited form because that's not a good idea. So the question when you're trying to determine what type of indemnity to use is, do you want to require the subcontractor to assume the GC's own negligence? And then, if the answer is yes, how much of the GC's negligence do you want the subcontractor to assume? Now, broad form indemnity, as the term, as you would expect from the name, is the broadest form of indemnity available. And the way to think, the easiest way to think about it is that it indemnifies a party even for that party's sole negligence. Those are sort of the magic words, sole negligence. And an example of broad form in language you'll see in indemnification provision that provides broad form indemnity is even if caused in whole or in part by any act, omission, or negligence of the general contractor. So that would be the type of provision you would see in a general contractor subcontract in which he is demanding or it's demanding broad form indemnity from its subcontract. Now, there's a lot of different variations of that, but if you're looking through a contract and you're trying to identify what type of indemnity is being demanded of you, if you see in whole or in part, that is broad form indemnity. And let me tell you what broad form indemnity means in reality. It means the party's sole negligence. If you're a subcontractor, you're agreeing to indemnify that general contractor, even for the general contractor's sole negligence. Now, getting back to how it's interpreted under the law, for construction contracts specifically, broad form indemnity is permitted in Pennsylvania if the provision is properly drafted. And I'm going to talk about some of the language you'll see in terms of what's enforceable and what's not enforceable, because I can tell you it's not necessarily intuitive. Broad form indemnity is prohibited by statute in Delaware, Maryland, and New Jersey. And that's not, you can't get around the statutory prohibition in Delaware, for example, or Maryland or New Jersey by saying although the situs of this project is in Delaware, we're going to use Pennsylvania law to interpret the contract, most specifically the indemnification provision. You're not permitted to do that. So if you're doing projects in Delaware, Maryland, and New Jersey, even if you've agreed to a contract that has broad form indemnity, it's not going to be enforced by the court, or I guess more specifically, it shouldn't be enforced by the court. Now, the downside to broad form indemnity, if that's something that you're a general contractor and you're requiring of your subcontractors, it's difficult to negotiate the acceptance of it. The reality is you're going to you should really expect major pushback from your subcontractors. And the reason is because there's a perception that broad form indemnity isn't fair. It's not fair to require a subcontractor to indemnify a general contractor if the general contractor was solely negligent. And from I don't necessarily disagree, but I have a good example that I like to use when I'm negotiating as to why general contractors want broad form indemnity. And I'm going to go through this pretty quickly. The biggest claim risk that a general contractor is facing from an indemnification standpoint on a construction project is being sued by an employee of a subcontractor who has been hurt on the project. And as we all know, or we should know, the employee of the subcontractor, his sole remedy against his employer is under the workers' compensation system. So he files a workers' compensation claim. He gets his medicals paid for. He gets a percentage of his wages paid for, not entirely paid for his wages because there are limitations on how the indemnity benefits under the Workers' Compensation Acts in various states, which can be relevant if you're an iron worker and you're 40 years old and making $120,000 a year. So the comp system also doesn't pay for pain and suffering. So what happens is that so that the employee can be fully compensated for the injuries that he sustained on the project, he's looking around, or his attorney more accurately is looking around to sue someone. And what the attorney will generally do is going to sue the owner because the owner has a non-delegable duty to provide a safe land, and going to sue the general contractor because, as we know, the general contractor under the law is generally responsible for site safety, and most specifically, definitely under OSHA. So general contractors get sued a lot by subcontractor employees. And when that lawsuit is filed, the attorney for the injured subcontractor employee doesn't ever cast any type of blame on the subcontractor. They don't plead that the reason why he fell off of the roof was because the subcontractor failed to provide him with appropriate safety equipment and harnesses and tie-off points. They never say that. And the reason is because they can't collect and they can't name the subcontractor, so there's no reason to point the finger at the subcontractor. Rather, they're pointing the finger really at the GC and to a certain extent the owner. So if the GC is the only one who gets sued, all of the allegations against the GC are going to be, you, the GC, did something wrong. You, the GC, were negligent. You, the GC, didn't provide a safe work site. And there's the possibility under those circumstances that the GC could be found solely negligent. However, between the GC and the subcontractor, putting the kind of the law as to how that's going to play out in a tort case, if I'm a general contractor, I hired the roofer who was the subcontractor whose employee fell. I hired this roofer because they have a good safety record. They know what they're doing. They do good work. Their guys are union guys and they're trained. And so to the extent that there was a failure on the part of the subcontractor to provide safety equipment or provide a safe work environment on that roof that led to the fall, I think, at least as a general contractor, that it's the subcontractor's responsibility, not my responsibility. I may have general site safety responsibility, but I can't be everywhere at the site babysitting everybody who's working on that site. I hire subs, competent, safety-conscious subs, to do the work, and I expect them to babysit, more or less, to make sure that their employees are working in a safe and appropriate manner. So if it turns out that the employee isn't, and because of that, the employee is injured, I want to be looking to that subcontractor to defend and indemnify me under the obligations in the indemnification provision. And I want them to do that even if I could, under the law, be found solely negligent, because after all, between me and my subcontractor, we know who's really at fault here, who really has the responsibility. It was the subcontractor who should have made sure that its guys were working safely. So that's my stump speech on why sole negligence and broad form indemnity is appropriate and a reasonable request from a general contractor. I can tell you that I get pushed back all the time on that. So sometimes it works, sometimes it doesn't. So that's broad form indemnity. Just looking at some questions as we go through here. One of the questions was, are there limits on when a general contractor can ask a subcontractor to assume the GC's sole negligence? To the extent I understand that question, well, obviously, it's going to have to be included and negotiated in the contract, and it's limited based upon the state's law, and it's limited to the extent of the bargaining power of a general contractor. If it's bargaining with the subcontractor that it really needs because the subcontractor has provided a very, very favorable bid, then there's some business reasons why the general contractor may be more willing to compromise on a broad form indemnity demand, and perhaps, as we're going to move into, instead agree to intermediate indemnity. So the next form of indemnity in that broad, intermediate, and limited is intermediate. And the way I like to think of that in an easy sense is it's to indemnify a party for that party's own negligence, except if that party is solely negligent. So what does that mean? It means partial negligence. And you'll often see in an intermediate form in indemnification provision language like, even if caused in part by any act, omission, or negligence of the general contractor. And when you see that in part, not the whole or in part, but just the in part, you're talking intermediate form indemnity. Now, in terms of getting back to the law and how states interpret it, permitted in Pennsylvania, permitted in Maryland, permitted in New Jersey, prohibited in Delaware. So Delaware has a very strong anti-indemnification provision, and it essentially statute, excuse me, and and what the statute says is if it's a project involving construction, one party cannot require the other party to indemnify them for their own negligence. So if you're doing work in Delaware and you're a subcontractor, that's a favorable jurisdiction for you. And although you may run into GCs who are demanding broad form indemnity or demanding intermediate form indemnity, that is not going to be enforced by a court. Now, one of the advantages of intermediate form indemnity, although it provides less protection to the general contractor because the general contractor is only being indemnified in part, it's much easier to negotiate. You're going to get less pushback. You're not going to get the same type of pushback that you get when you're trying to get broad form indemnity. I just got a question. Is getting sued by a subcontractor employee is a major problem for GCs in Delaware, Maryland, and New Jersey? Yes. Getting sued by subcontractor employees is a major problem in every state because subcontractor employees are the trades. The employees from the trades are generally the most of them, the most on the project. And they're the ones who get hurt, and they almost invariably are going to try to sue the general contractor to the extent that the claim has merit or doesn't have merit. So the final form of the indemnification trinity is limited form indemnity. That's the type of indemnity that's going to be permitted under Delaware law. But the problem is that you're not indemnifying a party for that party's own negligence. And the language you'll often see is, but only to the extent caused by the negligent acts or omissions of the party providing indemnification. So if I'm the subcontractor, I've agreed to indemnify you, the general contractor, for my negligent acts or omissions. However, when you think about it, when lawsuits get filed, the GC doesn't get sued for the wrongful conduct of the subcontractor, as I talked about earlier. In fact, the plaintiff isn't, the injured employee isn't pointing the finger at all at its employer because he can't recover from the employer. So all of the allegations in a tort suit are going to be that the general contractor was actively negligent or was negligent through omission. you're never going to see allegations of essentially vicarious liability against a general contractor. And because of that, I think it's essentially worthless. You're really getting nothing by requiring a subcontractor to provide you with limited form indemnity. And because it's essentially worthless, it's permitted in all of the states. So you're going to be able to include that in your contract in Delaware, and it's not going to be worth the paper that it's printed on, in my humble opinion. So I want to focus on Pennsylvania law and how Pennsylvania interprets indemnification provisions, since, as you know, I've said, it's somewhat unique among Pennsylvania, Delaware, and Maryland in that it does permit a broad form indemnity. So, as in a general sense, indemnification provisions, they're generally enforceable. There's no statutory prohibition in Pennsylvania as to indemnification provisions in construction projects. And that means that the owner can require the GC to pay for the owner's own negligence, and the GC can require the subcontractor to pay for the GC's own negligence. And that's typically how you see the risk are being taken because the owner, by owning the property, is assuming risk. The owner wants to push that risk down to its construction manager or general contractor, because after all, the general contractor is the entity that it hired to do the project and do it in a safe fashion. So if there's a problem with the project and it being unsafe, as the owner, I think the general contractor should step up. And that's why the risk shifting provisions are being pushed from the owner down to the general contractor. The general contractor is getting those risks pushed to it, and it, for the same reasons I said before, pushes it down to the subcontractor, because after all, it's the subcontractor that has control over its people, how they do the work, and whether they do it safely. So they should have responsibility for their work and how it's performed. So when you're looking at indemnification provisions under Pennsylvania law, they're strictly construed against the drafting party. So that's a normal thing lawyers talk about in contracting. If you've drafted the contract, then it's going to be interpreted against you. And we often see that in the insurance policies. So you don't get to negotiate your insurance policies. They're dictated by the insurance carriers. So to the extent that a provision in an insurance policy is ambiguous, it gets interpreted against the insurance carrier. And the same thing happens with indemnification. So if you're a general contractor and you have a crappy indemnification provision, it's going to be interpreted against you to the extent that some young, bright, handsome lawyer like myself can argue that it's ambiguous and shouldn't be interpreted as you, the general contractor, want it interpreted. You need another rule of contractual interpretation in Pennsylvania as applies to indemnification provisions is that you need clear and unequivocal language to be enforceable. And what clear and unequivocal is a decision that's made by the court. We'll give you some examples where I confused me a little bit, but the court is the final arbiter of what's clear and unequivocal. And because of that, standard broad contract language is not enough. As lawyers, we like to put in any and all claims, any and all liability, things like that, and we think that we're covering all our bases. Doesn't work when you're drafting indemnification provisions. You need to understand the law of the jurisdiction where the work is going to be performed, to the extent they have, whether they have anti-indemnification statutes, and you need to understand how courts have interpreted indemnification provisions so you can draft ones that are enforceable. And that's the challenge for us as attorneys in our construction risk management, in our construction contracts and risk management group, is that we represent clients doing work all over the country. And that means we really need to have an expertise in indemnification in all the states because they do differ. So I want to go through a couple cases, Pennsylvania cases, in which the court was asked to address interpret, enforce indemnification provisions. So the first one is the City of Pittsburgh versus American Asbestos Controls. This is a Pennsylvania Commonwealth Court case. So it's when municipalities are sued and they appeal, all of their appeals go to the Pennsylvania Commonwealth Court. So it's one of Pennsylvania's intermediate appellate courts, not the Pennsylvania Supreme Court, but kind of right there in the middle between trial and Supreme. And this was the language that was used in the contract. Any liens, charges, demands, losses, costs, including legal fees and court costs, causes of action or suits of any kind or nature whatsoever arising by reason of or during performance of work covered by this contract. So that is what was trying to be enforced. And the court took a look at that, and they said, and this was language in a City of Pittsburgh contract, and they were demanding indemnification from the contractor, and the contractor argued, well, look, that's not specific enough. That doesn't meet the requirements. That's ambiguous. And the court agreed and said the contractor was not required to pay for the owner's own negligence based upon that provision. Just want to take a quick look at some questions. One of them was, will this PowerPoint be distributed after the session? The answer is yes. You can get in touch with our marketing department and they will help with that. I see that my good friend Tim Irons has asked, I assume you always strike any provision in a contract that has wording to hold the subcontractor responsible for punitive and consequential damages if you represent the subcontractor. Obviously, as to punitive, absolutely, and we try on consequential damages. To the extent that you represent a party and can limit the contractual damages that the other party can seek, you most certainly want to do that. Give me 1 second here. I'm trying to get my slide to work here. Another case is the Greer case, and the example of the language in the Greer case, and this is important because it ties into the standard AIA indemnification language in the A201. The language was, but only to the extent caused in whole or in part by negligent acts or omissions of the subcontractor, and regardless of whether such claim, damage, loss, or expense is caused in part by a party indemnified hereunder. So this was a situation where you had an owner and a general contractor seeking to be indemnified by the contractor. And in this particular case, there had already the tender, the indemnification tender had been denied by the subcontractor. The case had gone to trial in that there had been an allocation of liability to the Commonwealth and to the general contractor. And the court took a look at that language and it determined that it was not specific enough to be enforceable. And the subcontractor was found not to be responsible for the indemnifying the GC and the owner for damages that were attributable to the GC's and owner's own negligence. And I mean, candidly, I've never entirely understood this decision, but importantly, that's what the court decided. That's the law. So if you see that language right there, which those of you who use AIA contracts, you'll see it looks awfully familiar, but only to the extent caused by, regardless of whether. So that's essentially the identical language that what we saw in Greer and was interpreted by the court is the identical language in the AIA 201 2007. And the court has determined that that language essentially provides limited form indemnity. It doesn't provide broad, it doesn't provide intermediate. It essentially says, you, under this language, you subcontractor, you do not have to indemnify anyone for their own negligence. And that's clearly, I mean, if to the extent that you rely on your GC who is relying on AIA's which is not that common, or if you're an owner, more importantly, and you rely on the AIA, you're expecting that you're getting some sort of robust indemnity from your CM or GC, and you're using that language, the standard language, you're not getting what you think you're getting. So it's important to understand that. So I don't think I've seen any case law, I looked at it relatively recently, in which the courts had interpreted the AIA indemnity provision, but I would speculate with a fair amount of strong conviction that if it does, it will narrowly interpret it just as it did in Greer, and it will not require a GC to indemnify the owner for damages attributable to the owner's negligence, and similarly won't require a subcontractor to indemnify a GC. So to the extent, again, takeaway on that, if you want robust indemnity, you do not want to use the AIA A201 language. So here's example, the Hershey case is example of sufficient language. And I'm not going to read this entire thing. I'm going to skip down to where it's bolded. It basically is, yeah, we're going to indemnify you for a bunch of stuff. People get hurt, things get broken. If it's caused in whole or in part by any negligent act or omission of the owner in this case. And then regardless of whether or not it is caused in part by a party indemnified hereunder. So that language right there was interpreted by the court to be enforceable. And interestingly, the court's reasoning was the regardless of language, the same kind of language that we saw in the Greer case, the regardless of language when used alone, meaning not coupled with that, but only to the extent language that was used in Greer. You can see it there. When you eliminate that, but only to the extent language, and just use the regardless of language, the court in that case determined that it was sufficiently specific to require the GC to indemnify the owner for the owner's own negligence. So I want to go through relatively quickly the Delaware, New Jersey, and Maryland and how they interpret. As I said before, Delaware statutory prohibition, Party A cannot require Party B to indemnify Party A for Party A's own negligence. We're back to limited form indemnity, and what did we learn about limited form indemnity? It's worthless. So the example of that, again, not to beat a dead horse, the GC cannot require the subcontractor to pay for the GC's own negligence. Any indemnification provision that's contrary to that is void as a matter of law. So you can sign a contract again. You can promise the GC if you're a sub broad form indemnity in Delaware, but not going to be enforced. Maryland and New Jersey are, as I said before, intermediate indemnity states. So they have statutory limitations, but not as broad as Delaware's. They do bar broad form indemnity, meaning no requiring sole negligence. They do permit intermediate form indemnity, meaning partial negligence. So the GC can't require the subcontractor to pay for the GC's own sole negligence, but the GC's partial negligence is permitted. And in terms of how they need to be drafted, there's no magic words, magic words required, but the provision has to clearly indicate that the Party A, or let's say the subcontractor, is assuming Party B or the general contractor's negligence. The idea being that you should be able to tell from the provision that to the extent you're a subcontractor, the general contractor is expecting you, the sub, to indemnify them, the GC, for their own negligence. So that's how we interpret, under the laws of the states around here, indemnification provisions. I just want to check some questions, see if we've gotten any others. There's a question, should a sub try to avoid indemnification of the architect? John, that's a great question. And I admit to some design professional bias. Perhaps that's because we don't represent them very often, and we are typically representing GCs and subs who oftentimes have claims adverse to architects. I never want to see a subcontractor agree to indemnify an architect. And I think the reason why that started is because of the AIA and the fact that the AIA is created by who? Architects. So when you prepare the draft form that people use, why not stick your name in there for additional insured status and indemnification? So I always like to cross it out. I think, you know, that when you're looking at the chain of contracting, design professionals are the hired help of the owner, just like general contractors are. They're a consultant, and I don't know why we have consultants treated differently. They have their own insurance. They should be responsible. They should be responsible. Also, the other thing, a problem with indemnification of an architect is that architects get sued for design professional, usually for their negligence in their design. And you, as a subcontractor or a GC, if you've agreed to indemnify the architect, you're agreeing to indemnify, unless there's a limitation, the architect for if they get sued because somebody gets hurt and they sue the architect because the building collapsed because it wasn't properly designed. You're not going to generally have insurance coverage for that. So that is a great question, John, and you want to avoid that at all costs. So, workers' compensation immunity. All of the states that we've been talking about all have workers' compensation acts, and although there's some small variations, generally a injured employee sole remedy is through the workers' compensation system to the extent that he suffers or she suffers a work-related injury. Still has an opportunity to file a tort action against someone else who's responsible for that injury, be it products liability or in construction against a general contractor or an owner, but can't sue its employer in tort. And importantly, that immunity, the immunity that the employer has against being sued by the employee also applies to being joined generally in lawsuits that are filed by the subcontractor's employee. So getting back to that example of subcontractor employee hurt sues general contractor, absent an indemnification provision, and absent an indemnification provision that's enforceable and has a waiver of workers' compensation immunity, the general contractor or any other party is not going to be able to join the subcontractor to the lawsuit. And that's important because that scenario I gave before, in which we talked about the GC being sued and the GC saying, hey, wait a second, this isn't really my fault. This is the subcontractor's fault because the subcontractor, you know, didn't give the guy the tie-off, didn't give him a safety harness, or or didn't give him an appropriate tie-off point. There oftentimes is real liability on the part of the subcontractor, but the Workers' Compensation Act protects them from being sued both by their employees and being joined to lawsuits by by third parties. Having a problem with my clicker here, give me a second. Check some questions real quick. Okay. Having a little technical difficulty here. Okay, here we go. Waiver of workers' compensation immunity. So in order to make a indemnification provision enforceable because of the immunity provided by the various state workers' compensation acts, you need to have language waiving that immunity. And that waiver is permitted in all the states we've been talking about, Pennsylvania, New Jersey, Maryland, and Delaware. However, in order to do it, you need specific language that actually effectuates that waiver. General language is not going to be enough and not going to be deemed to be enforceable, such as language like, you're indemnifying me for any and all claims. That doesn't presume that that indemnity includes in claims brought by employees of subcontractors. So in order to make that language enforceable, the waiver language must indicate that the employer intends to indemnify the third party. So let's just say in our usual scenario, the subcontractor intends to indemnify the general contractor against claims on the part of the subcontractor's employees. And you do that by either expressly waiving the employer's immunity through reference to the workers' compensation statute, or, and this is in the case of Pennsylvania, I really haven't explored it thoroughly in other states, by specifically referring to claims involving injuries to its employees. And I'm going to show language for both of these. So here's an example of an enforceable waiver language that's you're going to often see something along these lines in a indemnification provision. And if I'm looking at, this is actually language that I use in my forms. You can tell it's written by a lawyer because it says the same things 3 different times. But I guess that's the whole idea of you want to make it clear and unequivocal. But the magic language here, really, to the extent there's magic language, is hereby expressly and without reservation waives any defense or immunity it may have under any applicable workers' compensation laws or other statutes or judicial decision disallowing or limiting such indemnification and consents to a cause of action for indemnity. That will be deemed to be enforceable by the court and determined to be a waiver of workers' compensation immunity. The other way was, I said there was a second way of waiving workers' compensation when you're in Pennsylvania specifically. And here's that language I've highlighted in this kind of long indemnity provision, which if you're reviewing it, you might kind of just, if you're looking for, okay, do I have a waiver of workers' compensation immunity in here? Okay, I'm looking for a reference to the statute, workers' compensation statute, like we saw in this version. I don't see anything like that. Well, you're tricked a little bit because the operative language that's been interpreted by Pennsylvania courts as waiving workers' compensation immunity is including subcontractor employees. That's sufficient. From a drafting standpoint, I don't like to do that. I think that's tricky, and I think that when you're contracting with a party, you want to, you're not, at least as it comes to indemnification, I want to be clear as to what I'm requiring of the subcontractor in the subcontract. I want them to understand what the risks that they're accepting. I'm not trying to sneak one by the goalie. I don't think that's good practice, or at least not the way I practice. So I'm more of a fan of the express waiver, that there's no issue that the subcontractor or somebody reading this over understands what's happening here, as opposed to what I think is more of the tricky way to put it through. So I want to talk about some indemnification provisions in GC subcontracts. And this is, I remember when I first started sort of developing a practice in risk management associated with the construction, looking through some contracts of large Philadelphia area GCs, some of which now have been bought out by national GC companies. But here's one of those. And I think at the time I was appalled by this. I have since, if you've ever worked with me and you've seen my indemnification provision, you'd say, I think you protest too much because Jonathan, your provision's even worse than this. But you can tell when you see a indemnification provision that's this long and has this many words and has this many any's and all's in it. A good rule of thumb is if you're a subcontractor reviewing this, you are getting screwed, no doubt about it. This is the kitchen sink approach. So, oftentimes, the longer it is, the more robust it is. Not always, because I see a lot of bad cut and paste jobs. But one of the things you can be really relatively confident that if you're dealing with sophisticated owners and you're dealing with sophisticated general contractors, they're going to have robust and enforceable indemnification provisions. Here is a example of I gave you the kind of the in whole or in part language. Here's an example of indemnification for sole negligence that you would see in a contract. Subcontractor assumes the entire responsibility and liability for any and all claims and or damages of any nature or character, whatever, for which contractor shall be liable under the contract documents or by operation of law with respect to the subcontractor's work, and agrees to defend and hold harmless and indemnify the contractor, the owner. Professionals, consultants, never like to see that. Professional consultants, terrible, and all of their agents. And I think, John, you were the one that you brought up this issue about architects. Another one of my bugaboos is agents. I always strike out agents. My position is always, when I'm negotiating indemnification provisions, if you want me to indemnify, you want my client to indemnify someone, tell me who that person is. I don't know who the hell you think your agents are. So I think, when I'm on the flip side of that, and I am representing somebody who has a subcontractor they've agreed to indemnify agents, I've been creative in the use of that. I guess in a bad way from a subcontractor standpoint, good way from my client's perspective at the time. But so if you see agents, strike it out, and that I've been very effective with that. I don't know who you consider your agents to be. Let me know who you're referring to so I can make an educated decision whether it's appropriate for me to indemnify them. And then we move on to the bottom. We get back to that whole or in part, whether or not due in whole or in part to any act, omission, or negligence of the contractor, owner, professional consultants, their consultants, and all of their agents, officers, shareholders, and employees. I don't have any real problem with the officers, shareholders, and employees. I do have a problem with agents. So here's an onerous provision from showing sole negligence. That's from a large GC that does work in the Philadelphia area. Now, a quick issue concerning indemnification. When we were looking at that prior slide, where you see to defend, hold harmless, and indemnify. Those are kind of the magic words. Defend, hold harmless, and indemnify. Sometimes it will say defend, indemnify, and hold harmless. I think that's the way. I like it that way better for no good reason. There's two different duties that are associated with that. The duty to indemnify, which is to pay for any settlements or verdicts that result, and the duty to defend, which is to hire the lawyers. And as we all know who've been involved in litigation, oftentimes the litigation costs can ultimately exceed the verdict to the extent that your lawyer's successful in defending the case. So the duty to defend is very, very important and integral part of indemnification. Those of you who are familiar with the way indemnification and defense obligations work with insurance contracts, it's different for indemnity. For insurance, you have a broad duty to defend. And the way that the courts have interpreted insurance contracts is if there's any possibility based upon the allegations in a complaint that the carrier is going to have a duty to indemnify, pay for any verdict or settlement, then it has to provide a defense. It doesn't. It's a very, very, very low bar to get defended by an insurance carrier. And if you say, well, they used the word negligence and they said there was some property damage, I think you should defend me. Oftentimes you're going to get a defense. That's not the way. So the concept there is the duty to defend is broader than the duty to indemnify. However, that's not the way it works for indemnification provisions. The duty to defend and the duty to indemnify are together. And really, actually, under the law, the duty to indemnify does not accrue, meaning you do not have a right to enforce indemnification until there has been either a settlement or a judgment which you have paid. That's actually the reality of it. And under those circumstances, once you've paid a judgment, then you're able to go back and actually seek, if you have the right language, the reimbursement of all the defense costs that you incurred, the general contractor incurred, because you tendered to your subcontractor. You said, hey, you should defend and indemnify me under this indemnification provision. The insurance carrier for the subcontractor told you to pound sand, had to hire the lawyer, and your insurance carrier hires the lawyer, and they defend the case. If you're successful at the end of the day, the carrier is going to, for the subcontractor, reimburse all of those defense costs. But that's not what you want to happen. What you want to have happen, if you're the general contractor and you have indemnification provision, is that you want to separate the duty to defend from the duty to indemnify. And you wouldn't, by contract, broaden the duty to to defend, to make it more like that example I gave as how insurance policies are interpreted. And here's some language that you'll often see in which the GC or the owner is trying to broaden that duty to defend in indemnification provision, to separate it from the duty to indemnify. And the magic language here is may potentially give rise to indemnification. So in addition, subcontract shall defend the indemnified parties against any claim which may potentially give rise to indemnification of the indemnified parties, even if such claim alleges that the indemnified parties are wholly or partially at fault for causing the loss. So by using that language, you have triggered an obligation of the party from whom you're seeking indemnity, let's say the GC to the sub, that's for the sub to, before the whole issue of owing an obligation to indemnify is decided, to provide a defense to that claim. In my standard indemnification provision, I have a paragraph that discusses this issue for the specific purpose of broadening it. Let me just see if I can get my clicker to work here. Give me a second. Still working. Apologize for the difficulty. So, another provision that I often see and that I include in my indemnification provision, but you'll see in most large general contractors, is the concept of an ongoing indemnity obligation. So in this one, it's the subcontractor's obligation to defend, indemnify, and hold harmless shall continue after completion of the work, final payment, and termination of this agreement, it being agreed that such rights and obligations are and shall be of a continuing nature and effect. Why is that important? Well, it's important because there are many situations in which a general contractor is going to want indemnification after the project is over, and sometimes even after the subcontractor has been terminated. So let's say you're a site contractor. You built you repaired some steps at the 30th Street Post Office as part of your contract. You were hired by the GC, and someone 2 years after the project's done falls down those steps, and the GC gets sued. Well, the GC is going to want to tender that claim to you, the subcontractor, pursuant to its indemnification provision, and say, hey, look, someone fell down the steps. The allegations are the steps were negligently constructed. You constructed them. This is your responsibility. I want you to defend and indemnify me. if you're looking to have your indemnification provision enforceable in those circumstances, you want to make it crystal clear that that indemnity obligation continues beyond the completion of the work under the contract, and even if the subcontractor is terminated. Because remember, the courts generally, that clear and unequivocal language is because they disfavor these indemnification provisions. They disfavor them, although they do enforce them if they're clear. So when you're drafting these, your goal, or when you're reviewing these, you really want to see, is this language clear? Is it clear that that indemnity obligation is going to survive the termination or completion of the contract? So we have 5 minutes left, and we're down to, I think, two or three slides. So we're on target. Obviously, you know, when you're shifting risk down, you're relying on the financial viability of the person to whom you're shifting that risk. But I feel more comfortable if there is a financial backstop of insurance. And you know, I'm going to be giving another webinar on additional insurance provisions, because that's kind of I like to think of the belt and suspenders of risk shifting. You demand indemnity and you demand additional insurance status, and you hope that one of those works when you have a claim in which you want a subcontractor to defend and indemnify you. So when you're drafting indemnification provisions, you have to draft them with conceptually as to whether or not there's going to be insurance coverage under the general liability policy for that subcontractor. And obviously a general liability policy provides coverage for personal injury and property damage arising from the negligent operations of the subcontractor. So when you see indemnity provisions that go beyond indemnification for personal injury and property damage, you're not going to get insurance for that. I think it's good to seek indemnity from your subcontractors for, let's say, a cost associated with having to get a lien removed, for if there's an OSHA violation that was caused by the subcontractor, but you're not going to have insurance coverage for any of that. Generally, you have insurance coverage for personal injury and property damage under a GL policy. So, really, when you're looking at a GL policy, they will provide a standard form, ISO form, general liability coverage form, provides coverage for a tort obligation that you, as the insured, have assumed of another. So essentially, an indemnification provision. And we often think of those types of claims, those claims that are being brought by an employee against the general contractor that are then pushed back to the subcontractor, are third party over. They're arising from the workers' compensation waiver. And although the standard CGL policy exclusion that talks about contractual based claims, it has exceptions if it's triggered by an insured contract, and that insured contract is that tort obligation. So long and the short, generally under a standard ISO, the standard industry insurance coverage form for general liability policies, and we're going to get to, there are some exceptions, there will be coverage for an indemnification obligation that is assumed by a subcontractor. And that's important because when you're a subcontractor and you're reviewing an indemnity provision, you need to review it from its, am I willing to accept this? Number one is, do I think this is fair? Am I willing to accept this risk in order to do this project and make the profit that I'm expecting to make? That's the first question. But the second question, which informs the decision you make on the first question, is, do I have insurance coverage for this? Because I as an attorney, see insured risks to be much different than uninsured risks. You may not like the fact that you're assuming an indemnity obligation that there's going to be coverage under your policy because of the claims made by that GC. It could raise your rates. It's going to affect your loss history. You're not paying for it. Your insurance carrier is paying for it, unless you're in a captive program, which is a whole different situation, or you have a high deductible or SIR. But generally, those obligations are going to be covered under your GL policy, as opposed to you reaching into your own pocket. One of the questions that I always I'm always asked is there coverage for sole negligence under a standard CGL coverage form? Meaning that if you agree to broad form indemnity, if I agree to indemnify a GC for that GC's own negligence, sole negligence, whole or in part, am I going to have coverage for that? And I've fought this battle with a number of different brokers. It's my position under the standard coverage form, you should have coverage. Remember, whether you should and you will are two different issues, because what insurance companies should do is not always what they do. So my position is that you should have coverage. Others disagree with me, just to be candid about that. One of the things when you're a general contractor or an owner, and this is important if you're a GC as well, I'm sorry, a subcontractor as well, is you need to make sure, you need to know whether that policy, the policy that's being held by the sub, has something called a CG 2426 endorsement. That endorsement changes the definition of an insured contract, and it makes it so it changes to must be caused in whole or in part by you or those acting on your behalf. So the way I look at that is that the CG 2426 eliminates any chance of there being coverage for a sole negligence or a broad form indemnity obligation that you've assumed. It's getting more and more common because carriers understand the risks associated with indemnification, and they're seeking to limit that risk through the through this CG 2426 endorsement. However, by eliminating their risk, they're limiting the coverage that the subcontractor has for indemnity obligation. If you're an owner or you're a GC, what you absolutely don't want to see, and part of my insurance requirements, I have a prohibition on actually the CG 2426 and the CG 2139. It's just CG 2139. That eliminates contractual indemnity coverage completely. So you often will not see that in the admitted market, meaning the Travelers, Liberty Mutuals, Zurichs of the world. That's much more common in the surplus lines market, insurance market. But that if you're a subcontractor and you have a CG 2139 in your policy, you do not have any insurance coverage for any type of indemnification obligation that you've assumed, whether it's intermediate or broad. So that is not something that you want. And when you're an owner in your GC, you want to make sure that you're hiring folks who do not have that. So that's it. I know it was kind of a whirlwind, an hour and 2 minutes, but I appreciate everyone participating and helping me out with this webinar. I hope you found the information beneficial. As I said before, the slides and the link to the recording will be circulated sometime after the webinar, so keep an eye out for that email. I know there are some people who reached out and said they wanted to participate but had conflicts or had colleagues who wanted to participate and weren't able to. You'll get a link and you can pass that link on. I'm sorry, we kind of ran out of time for questions and I wasn't able to answer a lot of them. So if anyone has any questions about what I said, about the topics that I covered, or really any other issues that you have that relate to risk management issues, feel free to give me a call. If you're a company and you think that this type of presentation, along with some explanation of insurance requirements, would be something that would be beneficial to have a presentation to your team, that's something that I come out and I do, and I'm more than happy to do it, so just let me know. So thanks, everyone. I appreciate you taking an hour out of your day to listen to me drone on about this, and I hope everyone has a good rest of the day. Thanks.